Good evening. Today we are presenting the assigned topic of Section 8 of Evidence Act 1950, and we are from Shu Associates, and this is our group members, in which the name listed according to the picture from left to right. Moving to the introductions, Section 8 discusses about the evidence of facts showing motive, preparations, and conduct of those involved in the crime where such conduct influenced or is influenced by any facts in issue or relevant facts. The conduct should not be separated from the facts in issue or relevant facts. One of the requirements for admitting the motive-related evidence is that it must be comparable to direct evidence. But in the case of Karasim against PP, Federal Court ruled that the deceased son's motive evidence had to be discarded because it was a mere repetition of what his father told him before he passed away. Next, moving to the evidence constituting motive. In a criminal case, the prosecutions may attempt to prove that the accused had a reason for committing the alleged crime because a motive might support the likelihood that the crime actually occurred. The elements of criminal intent or mens rea must be proven to convict the accused. However, in practical, it is very hard to prove it. So here, the motive may help to determine why a person commit a crime. However, a person will not be charged simply because he had a motive to commit a particular act. Nevertheless, the absence of motive does not mean that the prosecutor lost 8 cases. So in the case of Datuk Mutahid bin Hussin and another against PP, although motive is not necessary to be established in the offense of murder, it would, if shown, tend to support the case against the accused so charged. In the case of Wong for Hin against PP, the defense attorney attempted to argue that against the admissibility of evidence that the accused had raped his daughter as a justification for killing her on the grounds that it revealed that the accused had the bad characters. It was contended that allowing the prosecutor to use such motive evidence, that is, that the accused father was a bad father, will be a bad character evidence. The accused will be shielded from any attempt to introduce evidence of his poor character by the safeguard provided under Sections 54 Clause 1 of the Evidence Act. However, the court applied the principle in Regina against Bo, which reflect that evidence admissible on the ground will not be rejected because it is inadmissible on another grounds. So thus, the court allowed the prosecutor to bring the evidence of motive, even though it may against the protections of character evidence under Section 51 Clause 4. Evidence showing preparations. Section 8 Clause 1 also provided evidence showing preparations. An act of preparation is any actions that result in the commission of crime or acts in the commissions of a crime, such as gathering, buying, obtaining, fixing, or removing an obstruction so that a crime can be performed. So, in the case of Tianga against PP, every crime has 4 stages. The first one is an intention to commit the crime. Second, the preparation for its commissions. Third, the attempt to commit it. The last, the actual commissions of the crime. So the mere act of planning to commit a crime and getting ready for it are not criminal activity actually. So that's all from me. Thank you.
Assalamualaikum and a good day, sir. In the case of PP against Azilah bin Habri, the motive can be seen by the act of disease that has wrote a letter stating that the third accused has kept and tried to kill her, and the deceased has several times disturbed and treating the third accused. The action of the deceased clearly caused discomfort and continued disturbance to the life of the third accused. Therefore, as explained under illustration A under Section 8 of the Evidence Act of 1950, the above circumstances are relevant because it shows that there is a solid motive for the third accused to respond or take actions against the deceased due to her behavior to the third accused. Next, the preparation of the previous conduct of the second accused can be seen when there is a recovery of a cartridge from inside the second accused car, and according to the ballistic test concluded, see that the cartridge has been discharged from the machine gun possessed by the second accused. It was confirmed by the constable that the said machine gun was issued to the second accused and only returned on 30 October 2006, which is after the disappearance of the deceased. The cause of death of the deceased was probable blast-related injuries, whereby by referring to illustration C of the Section 8 of the Evidence Act, the fact that the second accused has a weapon that may give the same effect as to the cause of death of the deceased is a relevant fact to show the existence of preparation by the second accused to commit the crime of murder on the deceased.
Hello and Assalamualaikum. My name is Ibtisam Othman, and I will be presenting evidence of motive under Section 8 and Section 54 of Evidence Act, which will be explained to the case of Lim Kong against public prosecutor. But first off, let's look at the Section 8 and Section 54 first. Section 8, Clause 1 constitute the fact would be relevant as evidence if it shows motive, whereas Section 54 is about presenting bad character evidence, which is only relevant in certain circumstances laid down by the provision. Otherwise, it will be irrelevant. In this case, Lim Kong has made an appeal against the decision made by the learned judge, in which the learned judge stated that the evidence introduced by the prosecution to show that the accused was in a state of financial embarrassment was purely evidence of bad character and therefore inadmissible under Section 54. However, the learned prosecutor argued that this evidence was admissible to prove motive under Section 8. So the judge in this case stated that the fact that Lim Kong was in a financial embarrassment is not an evidence of bad character, but rather a possible motive for him as he is pressed to find money to satisfy his debts, since it is a case of kidnapping someone for ransom. Moreover, the judge also recited cases involves bad character as evidence, and those cases show that the prisoner either had been previously convicted or was guilty of some graver moral misconduct. The point of excluding bad character evidence is that it would compromise a fair trial, as there are stigma against those who has bad character. However, the fact of financial embarrassment does not put on such stigma on Lim Kong. Therefore, the judge decided that the evidence showing the accused was in financial embarrassment was admissible under Section 8 and did not prejudice the fairness of the trial.
Section 8, Clause 2 provides that the conduct of anyone is relevant if the conduct influences or is influenced by any facts in issue or relevant facts. And there are two types of conduct which are mentioned in Section 8, Clause 2, which are previous conduct and subsequent conduct. Previous conduct is the behavior of a person, such as an accused person, prior to the occurrence of the facts in issue. And next, subsequent conduct. An accused individual, a victim, or a third party can all engage in subsequent conduct after a crime has been committed. For example, the accused is seen running away from the crime scene or is showing remorse after his actions. In the case of Buta Singh and PP, the appellant had been tried and found guilty of killing the deceased Harnam Kaur. The deceased has filed a police report some months prior to her death, claiming that the accused has attempted to act inappropriately with her, made threats to stab her. According to the claim by counsel, such a report was hearsay intended to demonstrate the truth of the deceased accusations. And as we know, if it's to demonstrate the truth, then it is inadmissible under Section 32. The report was admissible under Section 8 because its content demonstrates the persecution's claimed motive and showed ties between appellant and the deceased. It shows that the relationship between appellant and deceased was very tense and they are not in good terms. Even though a statement does not constitute conduct within the definition of the section, it is expressly permissible under the conditions outlined in Explanation 1 of Section 8 because it supports and justifies the deceased act in filing the report. That it was made was so important, and it does not matter whether the report states the truth or the content of the report was not true. The fact that it was made was very important to the court. That's all from me. Thank you.
My name is Muhammad Imran, and I'll be talking about the relevant evidence of conduct infers the existence of mens rea. Evidence of conduct is circumstantial evidence that may lead to inferences about the accused. It could imply that the offence was committed with mens rea. This is shown in the case of Hamidi bin Muhammad Isa against PP, where the accused was charged with drug trafficking and fled when the police approached him. It was implied that the accused knew there were drugs in the vehicle by his deliberate attempt to elude the police by jumping into a large concrete drain and stayed there until he was caught. Next, on the relationship between conduct in Section 8, subsection 2 with the evidence of inference in Section 9 of the Evidence Act. The evidence of conduct must have reference to the facts in issue if it is standard. It is not admissible if there is no proof that the conduct was influenced by any relevant or in dispute fact as required by Section 8. The situation has now become ambiguous by allowing the accused to use Section 9 to derive some conclusions that are advantageous to him. In the case of Palan bin Dadeh against PP, where the issue was whether the appellant being shocked when PW4 identified himself to him as a police officer should be taken in as evidence of guilty conduct. The federal court in this case distinguished between positive conduct and passive actions and emphasized the need to acquire further evidence before passive actions can be concluded to indicate guilt or otherwise. In this case, the shocked look of the accused person related to the facts in issue since the drugs were found tucked away in the jeans worn by him. Failure of the accused in giving credible explanation caused the inference of guilty conduct under Section 8 to remain unrebutted. Thank you.